Jonathan Kelly.
I'm here.
I find your behavior while you are on bond in this court unacceptable. You have repeatedly violated the conditions of this court, trying to use illness as a method of consuming alcohol. I cannot trust you to use the camera because you are not doing it as ordered. So I'm now ordering you to come and get a scram device on your ankle. And I'm going to tell you now, there's absolutely no tolerance. The next time you test positive for any kind of alcohol, any kind of substance that you're not supposed to be using, I'm going to put you in jail. And I don't care if counsel is up here crying, pleading, begging, this, that, it makes absolutely no difference to me. But using illness to be able to consume is unacceptable. And I'm not going to tolerate it any longer. Do you understand?
Yes, sir.
I'm modifying the conditions. You must have the scram within the next 2 days. If you fail to have it, I'm going to revoke your bond. We will continue with court settings on the 13th. No more waived appearances. So he must appear here on that setting, and we will go forward. How old is this case?
It's back from,
It's 88 days.
Yeah.
So I would suggest that we probably get moving on it, because if he does need treatment, prolonging the case is just delaying the inevitable. Right. And I don't want to do that. If Mr. Kelly needs treatment, then I think that we need to get him moving on it. But when I find someone that continues to violate, that tells me a lot. So, okay, Mr. Kelly, you now are apprised of what your conditions are. No more violations. 3 strikes, you're out. Do you understand?
Yes, sir.
Okay. All right. Thank you, sir.
Your Honor, are you reinstating? You have a warrant for his arrest now, misdemeanor warrant for his arrest now.
Did I not reinstate it the other day? I thought I did.
Yesterday, Your Honor.
Well, it still shows up as of this morning.
Kelly,
Yeah, it is reinstated.
it's reinstated. I reinstated it yesterday.
So Judge, are we taking away the portable and just adding a scram or just?
Correct. Yeah. There's no need for the portable if he's got the scram. But scram first, and then you take the portable off. Okay. And I keep a close eye, please, because I want to know if he has any more violations. That's it. Good morning, Mr. Stubbs.
How you doing?
How are you?
Can you, sir?
Is it Ivernal, Invernal?
It's Ivernal.
Ivernal. That's an interesting name.
Thanks.
Interesting.
It's
Great.
different.
All right. So, Mr. Stubbs, it looks like you are wanted out of Alabama for,
The possession of marijuana first degree theft.
wow.
Because of the amount. It didn't
Is
say
it a capital weed case?
I don't know how much it is, Judge.
Yeah. So it looks like you're wanted for a first degree possession of marijuana case. What would you like, Ms. Oko?
So Judge, we would like for a bond to be set for him to get out. Of course, I know, on this particular case, he has made the one court date that has actually been set, according to his bonds lady, and this would have been the second one, but due to issues happening with the court itself, there is a change of staffing at the jail, according to the bonds lady. And so they had issues with court resets, and they sent out wrong court dates, and people just didn't make those court dates because they never got it. And that's why Mr. Stubbs is here today. He is more than capable of going to his court date in Alabama, taking care of this warrant. And he does hope to get his bond renewed in Alabama because this was a mistake on their end. So he just wants a low bond so that he can pay it, take care of Alabama, and then come on back to his family here in Houston.
Do you have a lawyer in Alabama?
Somehow my lawyer got sick. Somehow he got sick and he was taking off my case. So instead of them sending my case to someone in the law firm with him, somehow I was appointed a court appointed.
And I know the new
I never-
name.
What I would
that I
suggest,
never knew about.
the thing is though, is that if they made a mistake, then many times they'll own up on the mistake and reinstate and release the hold.
That's what the lawyer was
And
trying to get the whole released. Him and the bondsman, they've been working together to try and get it released.
so what I would do is you'd use, I mean, because now here, I don't know if I'm going to give you a bond, Mr. Stubbs. I got to tell you that I take this extremely serious, right? I don't know you. I've never met you before.
Correct.
Everybody that comes over here tells me it's little bunnies jumping in the woods and rainbows and gumdrops, but when they get out, they turn into a completely different person. And my main concern is public safety. That's what I want, right?
I'll tell you firsthand, I'm an adult, sir.
I'm sorry?
I'm an adult. So therefore, I never missed a court date. The ones that I have had, I don't care where I'm at. If I have to drive 1,000,000 miles, I would drive 1,000,000 miles to show up for court because I don't want to be in this position. First of all,
In and
I
out
have
for some reason, and I don't know why.
four mistakes the courts made.
Tell me, how long has this warrant been open?
The warrant's been open since January 2024. It was a month before he picked up 2 felonies in our jurisdiction, impeding breath for a family.
So that warrant's been open since January.
Yes, Your Honor. And then a month after, he picked up 2 felonies in our jurisdiction, and assault family member, impeding breath, and evading motor vehicle. He said 3 failure to ID out of 2 different jurisdictions, and he had a prior fugitive case in 2006. Because of all those factors, I believe he's the definition of a flight risk. He literally drove away from the police and failed to ID himself at least 3 different occasions in 2 different jurisdictions.
Is that an allegation or something that took place?
Look, the only way that I really get to know you is paper, because that really tells me who you are. What you tell me now goes in here, goes in there, because I never met you before, right? So that's how I really get to know you. But the problem is this warrant from Alabama has been open for a year.
It's been open for 3 years.
No, the warrant that was been issued in this case. You've had an entire year to take care
I
of this.
never knew about the warrant because my bondsman wasn't contacted, nor was I contacted because
They're
the
not-
lawyer
That's
fell off the face of the earth.
It's your responsibility. No one is going to call you, hey, Mr. Stubbs, it's time to take care of this criminal case. Come on, man, it's time to take care of it. Criminal cases don't work like that, man. When you hire a lawyer, you hire them to defend you, and the more money you spend, the better representation you get, the more you pay to get babied, right? Like these really grandiose lawyers, they will baby the heck out of you, right? Because you pay for it.
All the courts basically, and every day until they tell me I have a new court date or my lawyer.
Yeah, if that's what it takes, then yes.
But Judge, and I wanted to say in his defense, the bonds lady did state that he had been in contact with her as per the new court date, whenever new court date was set out. And when they issued out the court date, she didn't know about it until he missed it. He didn't know about it until he missed it. He has been in contact with his bonds lady in Alabama. What I can do is I can reach out to his attorney. I believe his name is Chris Albert. I will reach out to him in Alabama and see if I can get some sort of written correspondence from a prosecutor in Alabama. That way they can kind of rectify this whole thing.
That would be, I just, not only do you have 2 open cases here, but you've also said he picked up other cases in other states as well?
No, I'm saying he has history in 4 other states. He's had,
History in 4 other states,
yes, Your Honor.
I'm not from
When-
Texas. I've just moved here. I haven't been in trouble in over 12 years,
You've got 2 open felony cases. It's
And
been open since
I'm ready to
February.
Take them to trial right now today because when those allegations, I was in jail.
So don't talk about the cases.
Trial now. I'm guilty to prove innocent, right?
Let's do this. Ms. Chisholm, can we roll it to tomorrow? Will you reach out and see If it is a true error in their part, maybe they
Absolutely.
will release the hold.
Yes, Judge.
I don't feel comfortable. This thing's been open for a year. You've known it's been open for a year. I mean, and now the only reason you want to take care of it is because we got you, when you should have
I never
been
knew
proactive.
I never knew I had a warrant.
It's okay. And Judge, I'll get some written correspondence.
To know.
Hold on,
I
Mr.
haven't been in
Stubbs,
any
Mr.
trouble.
Stubbs, hold on. I'm gonna get some written correspondence to that effect. That way we can have something on paper. And if we can't get it on paper, then we'll take it on from there. But I'll do my best to reach out to Alabama folks.
Mr. Stubbs, she's great. That's why we have her working with us to try to help resolve these issues. You know, if they can, hopefully they'll release the hold.
Yes, Judge. I'll start working on it now, but we'll roll it till tomorrow.
Yeah, okay.
So I will have to come back to court tomorrow.
Yeah.
So I will be deprived of sleep, held under duress, and still have to go through the same. I haven't eaten since Wednesday.
You haven't eaten since Wednesday?
Don't eat meat. They only bring you bologna sandwiches. I'm tired of going through it, Judge. I don't do anything
I don't know
wrong.
if they have vegetarian.
I haven't been in any trouble.
They have vegan stuff in jail.
When you peanut butter and jelly, they don't. They only give you that on the dorm. And if I'm here at court, how am I going to eat?
I mean, I work at jail. They have vegan meals.
But if I'm in court, how do I get a hot
So
tray?
let's see, you know, you can have someone give you commissary.
Johnny's.
You have commissary?
I can't go to commissary. I haven't been to commissary. I've been here a week.
Oh, you just got arrested.
I just got arrested I just got here last Wednesday. I was extradited from Dallas County to here.
Oh, so you weren't even here in Dallas.
I
You weren't
wasn't
even
here, so I did 10 days. They actually had dropped the warrant. Somehow I have a fugitive charge with a new case number that's not even the case number in Alabama.
That actually makes sense because we wouldn't have filed ours unless he made bond and we had no other interstate. So that makes sense.
And I tell you, it's going to continue to happen
Yeah.
eternally until you get back over there.
I mean, I think my lawyer died, so that I heard. I have a paid lawyer. I feel that my case should have went to,
If you got a paid lawyer and they drop the ball, then you need to go file a complaint with the state
I
bar.
just found this out.
Mr. Stubbs, we're gonna try and take care of it on our end, okay?
I've got Ms. Oko working
All
on
right.
it. Okay.
Yes. So he can go back. He can go back. Thank you so much, Judge.
Thank you, Ms. Oko.
Yes, sir. May I be excused?
Yes, ma'am.
Thank you, Judge.
You're the best.
Good morning, sir.
You're Trevor Flores.
Yes, sir.
Mr. Flores, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
Officers initiated a traffic stop after observing the defendant cross several lanes while failing to signal and almost causing a collision. Upon contact, the officers observed an odor of marijuana. The officers asked the defendant to step out of the vehicle and asked whether the defendant had the marijuana inside. The defendant admitted he did have marijuana inside as well as a firearm. During the search of the vehicle, the officers found a handgun in plain view on the driver's side floorboard, not in holster. And the officers also located 13 grams of marijuana under the passenger seat.
Got it. All right, Mr. Flores, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license? You do not.
I have a SR-22 in place. My license was suspended.
Okay. You're not allowed to drive. Do you understand?
Yes, sir.
If I find that you drive, I will have a contempt hearing. It's possible you face another 6 months in jail. I'm going to have you sign an affidavit with me today, promising you that you're not going to drive. Do you have liability insurance in your name? Car insurance?
Yes, sir.
I don't want you driving until you have a Texas driver license. You need to call DPS, figure out what to do to get your license. I'm going to give you the phone number now, but it's time for you to get your license back. And when you show me that you have your license and that you have car insurance, I will happily allow you to drive. But until that point, do not drive.
Am I not allowed with the SR-22?
No, I don't know what's going on with your license. I don't know if you've ever had a license. What's going on, Alex? Can you run it, please?
On the license?
Please.
Yes,
Yeah.
Your Honor.
I mean, I can't give you legal advice, okay? But as it stands, until you have a Texas driver license and liability insurance, don't drive. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. Do you understand? This is a condition of your bond. If I find that you have a weapon, I'm going to revoke your bond. I'm going to put you in jail. You will not get any more PR bonds. Do you understand, sir?
Yes, sir.
How old are you?
26,
What do you do for a living?
high school football coach.
And I see it is not eligible, and it says it's a mandatory suspension due to driving with license invalid, as well as an SR suspension.
Okay, so you even have an SR suspension. You can't drive at all. So this is now a bond condition. If I find that you drive, I'm telling you, HE double hockey sticks to pay. You understand?
So I'm not allowed to retrieve the weapon back.
I'm ordering you now, while this case is open, not to have any weapons.
Yes, sir.
Okay? Here, Stephen, do you mind giving this to me, please? This is the number to the driver's license division to DPS. You need to call them in the morning to figure out what you need to do to get your license back. Don't call them at 9. Don't call them at 8. Don't call them at 1:02. You're never going to get through. You need to call right when the phone lines open, which is at 7 o'clock in the morning. You'll get through, give them your license number and ask them what you need to do to get your license back.
Okay.
Once you do, I'll tell you, I'll take this off, you know?
Yes, sir.
Did you want to apply for an appointed lawyer?
Yes, sir.
Okay, I need you to fill out an application for me. I'll take a look at it. And then assuming you qualify, I'll give you a lawyer today. I'm going to have you sign this agreement with me today that you're not going to drive. And I want you to understand, Mr. Flores, I take this so serious. Don't drive. If you drove here, you can't drive home.
No, I didn't drive here. My father did.
All right, so I'll have you come up here, swear to us. May I have you go to Jamay, sign a reset, and then we'll have you fill out the application, okay?
Okay.
All right. I can appoint lawyers, but I have to follow certain guidelines, right? The guideline is you have to be at the federal poverty guideline level for me to appoint a lawyer. We don't just give it out. So, I'm sorry. So you here on you tell me that you have a 4,000 month income coming in. Are you married?
No, sir.
So you put here spouse or other household income. Who is that?
My girlfriend.
Okay, so it's not your money.
Well, we both work. We both work. So it's combined. It said total at the bottom. So I just added it.
Okay, but I don't think that that's your money then. It's her money and I'm not gonna, okay. I'm gonna grant it for you. Okay? All right, thanks. You can just take a seat. Thanks. Are you Omar de Jesus Guzman Lopez? Sir, you're charged with falsifying drug test results. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay,
On August 2nd, 2024, officers conducted a traffic stop in accordance to an illegal tinted front windshield and 18% window tint on the front windows measured by a tint meter. The driver was identified as the defendant, and when the defendant was advised the reason for the stop, he said, "I don't care, you give me a ticket for it." And the defendant admitted to smoking the marijuana the day before and gave verbal consent to the officer to search the vehicle. A clear plastic bottle containing a golden liquid was found in the driver's side door. The officer identified the liquid as synthetic urine. Another container of golden liquid was found in the center console. The defendant denied knowing what they were several times. The defendant stated that the synthetic urine was used for drug testing.
are you showing him on probation or parole for anything?
No, Your Honor.
All right. Mr. Lopez, I see that you do have a lawyer at this time. So what I'm going to do is I'm just going to have you take a seat. Your case is getting up there, so I'm just going to have him take a seat until Ms. Turner comes, and then we'll figure out how to go forward, okay?
Sure.
Do not leave, all right? Okay, please. All right, Mr. Guzman, you've been given a great offer where they're willing to dismiss the case in exchange for you doing several things. What all does he need to do?
Just an effective decision-making class, Your Honor.
Is that the only thing?
Yes, Your Honor.
Okay, all you need to do is an effective decision-making class, and they'll dismiss this case. That's something you can be done online, and it's only a couple hours. Your case is getting up there. It's time. We will give you a reset. Got to have it done, though. Do you understand? The quicker you do this, the quicker it gets dismissed.
Okay, Your Honor.
Okay, all right, thanks. All right, good luck, Mr. Guzman. Mr. Saulnier, Is that right? Saulnier? Saulnier. So you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Oh, yeah, I didn't even see that. Thank
On
you.
November 25th, 2024, officer conducted a traffic stop for a defective driver's side tail lamp in Harris County, Texas. The officer made contact with the defendant, the driver, and sole occupant of the vehicle, and observed signs of nervousness, such as not making eye contact and soft speaking. The defendant stated there was nothing illegal inside the motor vehicle, such as marijuana, and denied consent to search the vehicle. While waiting for a K-9 unit, the defendant stated he had THCA in the motor vehicle, and that was why he was nervous to allow the search. The K-9 arrived, the officer had the defendant exit the motor vehicle, and the K-9 conducted an air sniff around the motor vehicle. The K-9 alerted the motor vehicle, and a search was conducted. The officer located a glass jar in the center console with a green leafy substance known to be marijuana based on training experience. The officer also located several empty dime-sized clear bags with an 8-ball logo in the center console, as well as one dime-sized bag with a leafy substance in the driver's side door. The defendant stated he did not eat any substance, and the officer observed a green film on the defendant's tongue. The defendant stated the marijuana is THCA, which was not illegal, and that he bought the marijuana in clear bags, but the officer only observed one small piece of marijuana inside the bags. The weight of the marijuana found was 0.089 grams.
What was the stop for again?
For defective driver's side tail lamp.
Okay. Mr. Saulnier, I'm going to find that there's probable cause to go forward with the case. How old are you, sir?
23.
23. What do you do in life now?
I wash dishes and bus tables at a restaurant.
Okay. I don't want you using. I'm ordering you now not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I'm telling you now, it's not going to go well. You also are on probation for a very serious case, man. You know, you got to have a halo over your head when you're on felony probation. You know, really. You want to apply for an appointed lawyer, sir?
Some time to try to hire one.
Okay. I would get on it like tomorrow because you have another case that it's very possible they now file a felony warrant on you. So you got to be on the lookout. So I'll get on it quick. I'm going to have you sign a reset with Jamae. After that, well, I'll have you meet with Fleischer for your bond conditions. And then, oh, do you have a Texas driver license?
Sir.
Can you run his license, please? Do you have liability insurance in your name?
Sir.
Okay, as long as you have both, you can continue to drive. Otherwise, don't drive.
Eligible, Your Honor.
Is eligible?
Yes, Your Honor.
All right. Good luck. You know, your lawyer was extremely upset with you yesterday. And I'm going to tell you that when someone's has your life in their hands, it's probably not a good idea to have them upset, you know, because your proverbial life is in their hands, right? And you are facing up to 6 months in jail. So it could go very wrong very fast, you know? I'm glad. So you guys are okay. I'm glad. Yeah, that makes me happy, but you can't do this. This is not a good way to go. And this is not so we're set for trial today in this case. Just didn't want to go through.
We discussed alternative resolutions, Judge. I don't think my client's financial situation, life prediction will change in a month. That's consequences of their police today. And my client, I believe.
No PTI? Is she not calling? She's not eligible or?
Can't afford it.
I can waive everything. I mean, as much as I can.
PTI, they still, even if you waive the DA fee, I mean, there's $100 a month at least interlock fees they can't do anything about, you know, all the probationary or all the meeting fees that can't be waived.
Ms. Rochelle, you need to understand that you're going to pay for this one way or the other. The problem is that when you end up with the conviction, it's over and it will go on your record. It'll be there for the rest of your life. It's even there after you die. The state is going to get the money somehow, whether it's through fees and fines and court costs. Your insurance is going to skyrocket now. Insurance now is freaking nuts as it is now. With a DWI conviction, what do you think is going to happen? It's the same thing. You have the opportunity now where they have this diversion program where if you are granted entry and you complete it, the case gets dismissed. And you don't have all those other consequences. But the problem is that you'll have to foot a little bit money now, but it's going to save you a ton in the long run. Never take a half-ass approach to something because you're going to get a half-ass result. Your case is old is just about as old as Jesus, but I'm willing to give you time if you want to explore the PTI route, but you got to get on it lickety split like yesterday. If you want to, it's up to you, Will.
Yeah, we've discussed it in the past. Is this something you want to reconsider? Do you want to get?
I know I don't have a car now, so
You would have
Doesn't
to.
matter.
You'd have to get a portable device.
Get a portable device. You'd have to take the portable device. You have to promise that you're not going to drive. You sign an affidavit. All you would have to do is literally 2 classes, a little bit of community service, and just stay out of trouble. Don't drink, don't use, and it gets dismissed. The problem is it's a little bit of money, but you can have the fee waived. Is there anything else we can waive? What else can we do, Shatoria?
We can, go ahead,
No, I don't think there's anything else we can waive unless our programs are in-house.
I can waive the TRAS fee, right?
You can
So I can waive the TRAS fee, which is about $300. You can file a $300 waiver for the DA fee. You'll have to pay for the interlock, which is,
It's about $100 a month.
Right.
But
and then the classes, but that's it.
Well,
I typically don't still be, because I asked about the fees earlier, I still think even with all of those things waived, it would still be over $1,000.
Well, over the course of the year though, like it's not upfront.
Okay. Yeah,
Right?
that might be true, I don't.
Yeah, I mean, I don't think anything's upfront.
the program is for a year, but if you get everything done in the first 6 months, classes, community service, no problems with the portable device, they usually can dismiss after 6 months. If
Have
you're,
they, I thought did
they
they
stopped and they reinstated it.
Oh, they have.
Yes.
Oh, they see that? If you kick ass, they'll take you off in 6 months. Really?
yeah.
Judge, I just need to see if that was ever an offer,
Oh, well,
because I don't know.
I'm pretty sure it was. Her VAC was low and there was no wreck. She was driving on a rim.
And I was like trying to get away from where I was at. I was
just,
not in
yeah,
a
don't-
safe
don't-
spot.
there's no need to talk. I mean, the only thing, do you qualify is really the only question.
Oh, it's,
You know?
there's a out of state conviction she had. She was in a bad relationship and took a conviction on actually a felony case in Arkansas. So they were requiring a
It would-
mitigation packet.
It would need to be approved by Nathan Beadle, Judge, because there is prior criminal history.
Yay or nay? You tell me.
We can,
I'm willing to give you 2 weeks to get the mitigation packet done, but that's it.
I think we should.
I don't want you to make a decision now. Go talk
Okay.
and let me know.
Okay.
And then if you still want to do this, I'm happy to do it, but have that. So the tampering, I guess, is going to be dismissed in exchange for the discharging, right?
Correct.
Um, understand why it's not on here. You're giving up a lot of rights by entering into this agreement, Mr. Mann. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, it will go on your record. It will be there for the rest of your life. You can never take it off. Do you understand? Is this what you want to do? It looks like the agreement that you guys have worked out is you're pleading guilty to the discharging a firearm in the metropolitan area. If there was a weapon in this case, it now will be forfeited. You're not going to get it back. As a part of this agreement, they're going to dismiss your second case against you. It looks like they've offered you 12 days in jail, giving you credit for the 60 that you've done. So you're going to walk out of here today. What you need to understand, though, is that this is going to go on your record. And from now on, you're facing a minimum of 90 days in jail. Do you understand? This is not the way, man. Get a job. Do something worthwhile in your life. The older you get, life gets more difficult. The more convictions you rack up. It's so hard to be a black man today in today's society. All you're doing is making it more difficult, man. If you don't have an education, you ain't got a good job, You're going to be nothing when you hit 70, man. Life sucks when you're old and you ain't got money. Now's the time for you to work hard and do something. Good luck, man. Abandoned.
Judge, can I just confirm that cause of support? Just making sure, Judge. Thank you, Your Honor.
This is a shame, Cabrera. It's unfortunate that you have not, you've one violation after the other. At some point, it's going to catch up to you, and it's going to be at the worst possible time. Something is going to be going on in your life. Something's going to happen. Criminal cases usually tend to pop up, and people catch them at the worst possible time. Shh. This is going to go on your record. It's going to be there for the rest of your life. And I want you to understand, if you're ever in a car, you get pulled over and you have any kind of funky smell, they're going to see this. What do you think they're going to do to you? Right. Even if you've had a sip of alcohol, a toke, even the slightest, I wouldn't ever get in a car because you're begging for trouble. From now on, what we're doing today, you're facing now a minimum of 30 days in jail. If you're not smart enough to consider how to get home on a night of drinking, I will treat you like a child. I will put you over my knee like a child, and I will spank you like a little child, but I will do it with a ton of jail time. Do you understand?
Sir.
It's not hard. Every day, someone dies from a DWI in our county. Every single day. It's a shame. And it's so preventable. One button, $30, wherever you want to go in the city, don't matter where you want to go. Use it. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail, credit for the 8 days that you've done. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this agreement. There's no turning back. You can't change this. Do you understand?
Sir.
Here's the thing. You have to be punished somehow. Because I want you to understand that we mean business. And I don't think that there's any bigger way to punish someone than to hit them where it really hurts.
Sure.
Number one is jail. Number two, the pocketbook. You will be required to pay the fines and fees in this case. And if you don't, every $100 that you owe, you will sit in jail. Because I cannot possibly let you go the way that you have comported and the way that you've acted yourself these last 6 months or however long that you and I have been dancing. It's unacceptable.
Sir.
And I want you to understand that we mean business. And if you don't pay it, you're going to owe somewhere like $3,500 right now.
Sir.
And if you don't, $100 in jail, you will sit for 1 day for every $100.
Yes, sir.
You understand?
Yes, sir.
I'm going to suspend your license for 90 days. That is the minimum. Do not drive until you get a license. Otherwise, you're going to be right back over here. A suspended license case is a Class B, just like a DWI. Don't drive. The worst possible thing you can do is drive. Mr. Reyes.
Yes, Your Honor.
I want you to thank your lawyer, because I'm going to tell you now, any other person, they would have dropped you like a bad habit, but he has been nice enough to stay with you this entire time, no matter how many times he's had to put up with your behavior, not to mention, who knows if you even got any money for this case, you know? So you're lucky that you have him
Sir.
even here with you. How do you plead with the offense? Guilty or not guilty? I'll find you guilty. I'll send you the agreement. Good luck, Mr. Cabrera.
Thank you.
Thank you, sir. So I'll roll the core cost, but I want to pay the DPS fine, 3,000. Yeah. Listen, I'm giving you a lot of time to pay, but don't stop, because if you do, you'll be doing a lot of time in jail. And this isn't the one where you just bond out and you get, no, 100 for every day in jail. I'm going to waive the court costs, but you're going to be doing the other one. You understand?
Yes, sir.
All right, man. Good luck.
Thanks, Judge.
Got to get through to him somehow, Mr. Reyes.
You're right.
90 days. Good morning, Mr. Bio. You speak English, right?
Yes.
Okay. Shh. All right, Mr. Bio, you're charged initially as of, it looks like November 7th, you picked up an assault of a family member. I see now that you've picked up a new case. As of November 30th, you've picked up a violation of a bond condition or protective order. I don't know which it is. All I know is that you picked up a violation case. You're facing now another year in jail and or a $4,000 fine. I haven't done probable cause, so we're going to do that. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. Sir.
Officers were dispatched to a residence in Harris County, Texas in response to a disturbance. The complainant stated that he was locked out of his residence by his ex-wife's new boyfriend. Complainant went to the residence because his ex-wife had called them and stated that she was going to work. When the complainant asked who would be watching their children, the ex-wife said a friend. Complainant then heard defendant's voice in the background and went over to the apartment. Complaining witness is the same complainant.
You said he heard whose voice?
The complainant heard the defendant's voice in the background. I think that the complainant believed that the defendant would be watching his and his ex-wife's children, and that's why he went over to the apartment. Complainant is the same complainant from a pending AFM, and the apartment address where the defendant was staying is listed on a signed order of protection.
How bad of an assault were we talking in the original case? What happened is
I think it was a
Punch,
punching in
slap.
the face with a closed fist.
once, twice, thrice?
2 to 3 times, it looks like, Judge.
Okay.
And I can give some excellent background on that, that I think they're also still working through.
On the assault case, we issued a protective order, I would imagine.
Yes, and I've got a copy of that, Judge, if you need to
And
see.
did we order him not to have contact with this person?
Yes, but that's not the basis of the new charge. And so if we delve into the state's filed information, which is also the basis of the allegation he violated, well, imagine you're hearing both kind of in conjunction, the new charge PC, but also considering the questions of bail with respect to the first charge as well.
Of course.
What's been alleged in the new information is that Mr. Bio went to the residence of the CW, Mr. McWilliams. As of the date when we first appeared in court, the representation was made by both Mr. McWilliams, and then today, the representation was made by the ex-wife of Mr. McWilliams, who is the dating partner of Mr. Bio. So he is dating this gentleman's ex-wife. But she has confirmed to both of us that McWilliams has moved out of that residence as of the date of the first alleged assault. And McWilliams has told them that. They have been unable to reach McWilliams as of recently. But in the RIP call information, McWilliams confirms, I moved out that day and do not live at the address that's at issue in this VPO case. If you look at the filed information in that VPO case, it's a necessary ingredient of that allegation that McWilliams live at that address. It specifically says it in the last line.
You're saying in the protective order?
Yes, Jim. Oh, no, not the protective order. In the violation of protective order case, if you look at the state's filed information in that case, you will see the last line is, to wit, he was at the complainant's residence, but Mr. McWilliams doesn't actually live there. He moved out. Actually, was not on the lease.
He's still not supposed to have contact with this person.
Well, he's not. He didn't have contact with him. What happens is he's at a place that is not McWilliams' address, and then McWilliams, angry that he's there, still wanting to control his ex-wife, comes over there and busts the windows. And so that is
What's the window of
his ex-wife's house where Mr. Bio.
what's the ex-wife's name?
Shannon.
Shannon. Okay, so
And we both spoke to Shannon a few minutes ago.
and Shannon has how many kids with Mr. Bio, or do they have kids or not? So whose kids are they? McWilliams?
Williams and Shannon's children.
Okay.
I think there's two.
And so what's alleged in the newly filed charging document is that Mr. Bio went to the residence of McWilliams, which there's no PC to believe that. He did not go to the residence of McWilliams. He went to Shannon's residence. McWilliams does not live there, stopped living there, and the state can't meet the information. And so there's no PC on, my argument, Judge, is that there's no PC that the state or the officer.
So in our case, in the assault case, the protective order says that he's not supposed to go to this Spring Cypress, the apartment in Spring Cypress, right?
Well, contemplating that that's McWilliams's address.
Is that his address? Yes or no?
That is no longer his address, Judge.
Okay.
When that was filed, I imagine that was the original apartment, but on the
Because a lot of
day,
times they never updated. They just put the original apartment where it happened at, and they always assume that it's this, and, just,
so that's no longer the address. Mr. McWilliams moved out of that address on the day of the incident, and he told
Okay.
me he moved out. I believe that Shannon is the only name on the lease.
for the violation case, where is he alleged to have gone to?
He went to the address that's listed in the original MOA. So he went to the Spring.
Spring Cypress.
Right.
That's right.
Okay.
And
But what he's saying is that this person no longer lives there.
well, that's what McWilliams told the state. And that's what Shannon has told both the state and myself. And that is what our full understanding is. Now, I know that address is listed in the protective order, but what's contemplated by the protective order is don't go to a place where McWilliams lives. And McWilliams is not living at the Spring Cypress.
The problem is that we also have this address there because he could always go back.
Well,
He may not live there. Maybe he lives there partially. Maybe he comes and goes.
so what
So
told us was he was
he is-
kicked out.
Also as a preventative measure so that we don't want you to actually or accidentally bump into this person. And that's why we have this there, is that he did live there at one time. Perhaps he may go back. He left an article of clothing. He left pizza there, or whatever it may be.
Well, what's really happening is he wants to go back and continue harassing his ex-wife. And that is what Shannon has represented, I think, to both of them. I wasn't privy to their phone call, certainly what was represented to me. And
What do you want?
well, I want no PC to be found on the violation of protective order charge because an element of that offense that's been alleged is that Mr. Bio went to the residence of McWilliams. McWilliams does not live there. It's not his residence. So there's no PC to believe that that element is met.
What do you think?
Judge, I don't know, on this matter,
I gotta think, expressed in the order is that address was PC, but the actual information.
I will say, Judge, in the charging instrument, the defendant it does say, he's not allowed to intentionally or knowingly go to a place specifically described in the order. The address in the order, that's where he was staying. But in terms of
The address in the order, who was staying
the defendant was staying at the address in the order.
in this
In the
protective
original
order?
MOA, Spring Cypress.
Okay.
The defendant was staying there. But I will say in terms of PC, I'm going to defer to the court on this matter.
May I just read that little blurb of the information that I think is important for the court to hear? May I take a cheat and steal y'all's computer? Go ahead. So,
Do we still have a problem with him trying to communicate though?
no, he didn't want to have any communication. This gentleman comes over to the place and starts busting the windows.
I will say the complainant came to the place where the defendant was staying. Like, he initiated the contact in the situation.
And what's alleged is, and it's the last clause, maybe two clauses, it says a place specifically described in the order, to wit, the residence of a protected individual, namely Mark, and it should say McWilliams, but it says Mark Williams. So it's in order to meet this charging document, it would have to be that gentleman's residence. And he does not reside there, as by his own representation to the state. And so I'd ask that, and I know it's a very unique
How do
situation.
we go forward, though? If I find no PC, how do we go forward? No.
Well, goes back out on bond while we prepare our defense to the initial charge of assault, which I think they've seen quite a bit by way of background about Mr.
But how do
McWilliams.
we know that this isn't going to happen again?
I will say, I'm not sure where Mr. Byer will be staying after, if he were to get out on bond, but the witness, Shannon, she is no longer living in her apartment as of tomorrow. So that address will no longer, it won't even belong to any of them as of tomorrow.
Do we do a no contact with both?
I don't know if we would do no contact with the witness, with
With
Shannon,
Shannon?
but I would ask no contact with Mr. McWilliams.
You are now in a relationship with Shannon, right?
That's right, Judge. But yes,
So
I've instructed him, just let me answer for him, Judge. But he is in a relationship with Shannon. That's right. And he moved here from Hawaii to be with Shannon, and the ex-husband takes issue with it. And the ex-husband has a very violent history with Shannon. And so long-term, we think there'll be issues with case one even. But I understand that that's not really we're not there yet. I think the question is what to do if he is out. I do think, obviously, no contact whatsoever in any form, shape at all with Mr. McWilliams is appropriate, and that is what existed. Unfortunately, the state can't even reach McWilliams because he doesn't have a phone number that is even good.
have you run an NCIC check on this McWilliams guy?
We can see his in-county criminal history, but I can run a new check on him.
Do you see? I mean,
I don't want to
Pretty
be incorrect,
expensive.
but I think he's got violent history with Shannon, but maybe Judge, when you get to be my age, it's hard to remember all the details, but I think I recall that, but maybe I'm mistaken. I don't want to represent something inaccurate.
you have inherited a dangerous situation. Mr. Bio, you need to be very careful. You know, if you are in a relationship with someone and they have another person that's in their life that's like this, you could be the bearer of bad times. So you need to be very careful. You're in a very volatile situation. So you need to be careful going forward because it really could just could go out of control. You may need to get a protective order yourself. You know, it's very possible that you may need to get a protective order. So just be careful. You're in good hands. You ever have any issues, just reach out to Brian. We can always help you out as well. I'll find no PC on the violation of a protective order, but just be careful because there are a lot of vindictive people in this life that will they'll try to make your life a living hell. And you being on bond in this case, they can do that. They can say, hey man, he's doing this to me. He's threatening me. He's doing that. And if an officer doesn't know any better and they come up and they see that have this open assault, they may never take your word. They may never even speak to you. They'll just put you in county. So you gotta be careful. You know, you're in good hands. We'll help you out for as much as we can. Okay. Okay. So I'll find OPC on the,
And I think, Judge,
on the violation case. And I'm not going to revoke your bond on the original assault case, Mr. Bio, but you got to be careful, man. You know?
and Judge, I think you should also have him give his updated address to pretrial would be appropriate as well.
Okay. And I think there's probably somehow make a notation in everywhere so that we know where Shannon lives. You don't have an address for, McWilliams, so I don't know how we're going to handle
Well, I
that.
think the
But
protective order does say any address where McWilliams does reside. So whether or not, I mean, I guess that'd be a notice question, but we know not to go anywhere where he lives.
I think the issue is whether this other person's gonna now be, you know,
You understand all that?
if you have any questions, just be careful. Life's too short to live either in a 6x9 box or be 6 feet under because you got other people that have just, you know, just be careful. All right.
Thank you, Judge.
Good luck. Good luck, Mr. Bio.